The man had just turned 68 when a 29-year-old attorney looked him dead in the eyes across a conference table and said, "Sir, with all due respect, you should let someone qualified handle this." That someone qualified was him. Elwood Pruitt had spent 31 years as a union labor attorney before his hands started shaking. Not from age, from the medication they put him on after the stroke. It took 18 months of physical therapy before he could button his own shirt again. Another year before his speech came back clean. By then the firm had already replaced him. Quietly, professionally. With a handshake and a severance package and a crystal clock that he still kept on the kitchen windowsill because his wife, Marvine, said throwing it away would only give them the satisfaction. He hadn't set foot inside a courtroom in 4 years, and then the letter arrived. It came on a Tuesday morning, the kind of February Tuesday, where the sky looks like wet cement and the cold has a personal grudge against you. Elwood was at the kitchen table in his reading glasses and flannel shirt, drinking coffee that had gone cold while he worked the crossword puzzle. Marvine called from the front hallway, said something had come certified mail from a law office in Harrisburg. The letter was from a firm called Dalton, Voss and Mercer. It informed Elwood that his neighbor, a 72-year-old woman named Sylvia Crowell, was being sued. Not by a corporation, not by a stranger, by the management company of the very apartment complex where she had lived for 11 years. The place she had scraped together rent for every single month after her husband died, and she had to survive on a fixed income, and what little she'd set aside from decades of domestic work. The suit claimed Sylvia owed back fees for violations of her lease agreement. Pest control charges she had never been notified about. A hallway modification fee that appeared out of nowhere after she complained to the city housing authority about a water leak that had been ruining the ceiling above her bed for 7 months. The total amount they were demanding, $14,200. If the judgment went against her, she would be evicted. Elwood and Marvine had known Sylvia Crowell for 9 years. She brought cornbread at Christmas. She'd sat with Marvine in the hospital waiting room the night of the stroke, stayed there for 6 hours without being asked. She was 72 years old, 5 feet 1 inch tall, and she weighed maybe 130 pounds soaking wet. She kept a small garden on her balcony, tomatoes in the summer, marigolds when it got cold. She had never missed a rent payment in 11 years. Elwood read the letter twice. Then he folded it, put it in his breast pocket, and drove to Sylvia's apartment. She answered the door in her housecoat. Her eyes were red. On her kitchen table were 3 separate stacks of paper. Letters from the management company, notices from the housing court, and what looked like a repayment plan that someone had already filled out for her and told her to sign. "My daughter's boyfriend said I should just pay whatever I can and work out a deal," she said. "He said fighting it would cost more than what I owe." Elwood sat down at her table. He asked if he could see the lease. She slid a manila folder across to him. He read it the way he used to read every contract that crossed his desk, slowly, from the beginning, with a pen in his hand. He read for 45 minutes without saying a word. By the time he put the pen down, he had circled 11 separate items. "Sylvia," he said, "these fees are illegal." She looked at him. "Illegal how?" "Illegal as in they made them up. The lease doesn't authorize any of this. And this modification fee they're charging you, they triggered it within 30 days of your housing complaint. That's retaliation. That's a violation of the Pennsylvania Landlord-Tenant Act, Section 250.0205. I helped write the case law on it." She was quiet for a moment. "Elwood," she said carefully, "you haven't practiced law in a while. I haven't stopped knowing it." She agreed to let him look further before she signed anything. He drove home with photocopies of everything, and stayed up until 2 in the morning, at the dining room table, with his old casebooks and a laptop, pulling case precedents, checking current statute language, building a timeline of the management company's actions against her. When Marvine came downstairs at midnight and found him there, she looked at the papers spread across the table, looked at him, and didn't say a word. She just made another pot of coffee and set it beside him. 3 weeks later, Elwood Pruitt filed a pro se defense on Sylvia's behalf in Dauphin County Housing Court. The attorney on the other side was a man named Garrett Finch. He was with Dalton, Voss and Mercer, which was, as Elwood knew before he walked in, a firm that exclusively represented property management companies in eviction and fee recovery cases. Garrett Finch was 29 years old. He had graduated near the top of his class at Villanova Law. His shoes cost more than Sylvia's monthly grocery bill, and he had the kind of confidence that comes not from having been tested, but from never having had a reason to doubt himself. He was good. Elwood would give him that. He was well prepared and sharp, and he had clearly done this particular type of case dozens of times. He knew the procedural angles. He spoke fluently in the language of property management contracts. What he did not know, could not have known, because it had never occurred to him to ask, was that the man sitting across from him had personally argued 3 of the landmark cases that shaped Pennsylvania tenant protection law in the 1990s, that the legal standard Garrett Finch was relying on had a footnote that Elwood Pruitt had written into existence, that the modification fee provision Garrett was hanging the entire case on had been specifically challenged and narrowed by a 1998 appellate ruling that Elwood had filed himself. A ruling that was still on the books, still binding, and that apparently no one at Dalton, Voss and Mercer had thought to look for. The first hearing was a preliminary procedural conference. Standard stuff. Garrett Finch arrived with 2 associates and a paralegal carrying a banker's box. He looked at Elwood sitting alone at the defense table, no briefcase, just a folder and a yellow legal pad, and said, with genuine-sounding courtesy, "Sir, I want to make sure you understand the full scope of what we're filing. This is a fairly complex matter. Would your client like to request time to retain proper legal representation?" Elwood looked at him. "I am proper legal representation." Garrett glanced at his associate. "Of course. I just want to be certain Miss Crowell understands her options. She understands them fine." The conference moved forward. Garrett presented his primary argument, the lease agreement, the itemized fee schedule, the alleged violations. He cited 4 cases in support. Elwood wrote down the citations on his legal pad and said nothing. Then the judge asked Elwood if the defense had anything to add before the next date was set. Elwood stood up. He said he would like to note, for the record, that of the 4 cases opposing counsel had cited, 2 had been subsequently narrowed by appellate decisions. 1 had been outright overturned, and the 4th, the one Garrett had cited most heavily, did not, upon close reading, actually apply to modified fee structures assessed after a tenant complaint. He said he would like to submit a response brief that addressed the statutory foundation of each claim individually. He said he would also like to note that under Section 250-205 of the Pennsylvania Landlord-Tenant Act, fees assessed within 30 days of a formal housing complaint were presumptively retaliatory, and that the management company's own maintenance records, which Elwood had requested through a public records inquiry to the City Housing Authority, showed that the water leak in question had been reported to the company 7 months before Sylvia Crowell filed her formal complaint, and that no action had been taken until after the complaint was filed, at which point action was taken not on the leak, but in the form of the fee schedule now at issue. He sat back down. The room was very quiet. The judge looked at Garrett Finch. Garrett's expression had not exactly changed, but something behind it had shifted. The way a room shifts when someone turns off a light you hadn't noticed was on. "Counsel," the judge said to Garrett, "are you familiar with the appellate decisions referenced?" There was a pause that lasted maybe 2 seconds. In a courtroom, 2 seconds is a very long time. "I'd want to review them before commenting, Your Honor." "I'd suggest you do," said the judge. "We'll reconvene in 3 weeks." After the conference ended and they were in the hallway, one of Garrett's associates leaned over and said something quietly to him. Garrett looked back toward the doorway, where Elwood was helping Sylvia put on her coat. No one said anything else. The next 3 weeks were not easy. Elwood's hands were not what they used to be. He dropped his coffee mug twice. There were mornings when the words on the page swam a little before they settled. He didn't tell Marvine about those mornings, and she, being Marvine, understood without being told that the best thing she could do was not ask. He worked every day. He pulled the maintenance records and built a timeline that made the retaliatory motive undeniable. He found 2 previous tenants who had filed housing complaints against the same management company and subsequently received fee assessments. He located one case from 2019 in which the same company had been cited for a violation, so similar to this one that the language of the prior complaint could have been swapped in with only the names changed. He wrote a 12-page response brief. Then he cut it down to 8 because, as he had always told his junior associates back in the day, if you can't say it in 8 pages, you haven't thought it through clearly enough. On the morning of the second hearing, Sylvia arrived at court in a navy blue dress that she said she'd bought when her youngest graduated college. She sat straight in the gallery and folded her hands in her lap and didn't look at anyone from the management company's side of the room. Elwood set his folder on the defense table. Garrett Finch arrived with the same team. He acknowledged Elwood this time with a nod. A real one, not the kind you give someone you're dismissing. Something had changed in his manner. Not humbled, exactly, but recalibrated. Elwood recognized it. He'd seen it in opposing counsel before, the particular adjustment that happens when someone realizes, midway through a case, that the person across from them knows more than was apparent. The hearing took 2 hours. Elwood presented the maintenance timeline. He presented the 2 prior tenants' testimony, sworn affidavits he had taken over the phone. He entered the 2019 citation into evidence. He walked through the statutory retaliatory fee presumption, step by step. Slowly, the way he used to walk juries through technical arguments. Not talking down to the judge, but building the logic brick by brick so that every brick was visible. Garrett challenged the prior tenants' affidavits on hearsay grounds. Elwood cited the exception. Garrett pushed back. Elwood cited the case. Garrett went quiet. At the end of the second hearing, the judge said she had enough to render a decision and would do so within 10 days. The decision came in 8, all $14,200 in fees. Dismissed. Every single one. The court found the modification fee retaliatory within the meaning of Section 250-205. The court further found that the pest control charges had been assessed without proper notice, in violation of the lease's own terms. The management company was ordered to pay Sylvia's court costs. But that was not where it ended, because attached to the decision was a note that the court was referring the matter to the State Attorney General's office for review of the management company's fee practices, based on evidence of a pattern of retaliatory behavior against tenants who had filed housing complaints. The 2019 case, the prior tenants, the maintenance records. Elwood was sitting at the kitchen table when the copy of the decision arrived. He read it once. Then he set it down and looked out the window for a long time. Marvine came in and stood behind him and read over his shoulder. When she finished, she put her hand on the back of his neck, just rested it there for a moment, and then went to get his coffee. Sylvia called 20 minutes later. She cried for about 3 minutes, without saying anything intelligible. Then she pulled herself together and said, "Elwood, I need you to tell me what you need. Dinner every week? I'm making your dinners. Don't argue with me about this." He didn't argue. The story didn't end quietly, though. Things like this rarely do. Within 2 weeks, word had spread through the apartment complex. 3 other tenants came forward, saying they'd received similar fees after filing maintenance complaints. 2 of them had already signed payment plans. 1 of them had already moved out rather than fight it. A local legal aid organization contacted Elwood after someone shared the court decision on a neighborhood Facebook group. A journalist from the Harrisburg Patriot News called. The management company, for their part, released a statement saying they stood by their lease practices and that the ruling had been based on a misreading of the applicable statute. Elwood did not respond to the statement publicly. He didn't need to. The ruling was a public document. Anyone could read it. What he did do was spend the following month helping those 3 other tenants prepare their own cases. He didn't charge them. He sat at Sylvia's kitchen table with each of them, one at a time, and went through their leases the same way he'd gone through hers. Slowly, from the beginning, with a pen in his hand. The first of those cases settled in the tenant's favor before it ever reached a courtroom. The management company's counsel, not Garrett Finch this time, someone more senior, called Elwood directly to negotiate. He was pleasant on the phone, professional. He did not make the mistake of underestimating the man on the other end. I've been thinking about this story for weeks, turning it over, looking at it from different angles. What I keep coming back to isn't the courtroom moment, as satisfying as that is. It's the Tuesday morning in February. It's the fact that Elwood Pruitt, a man who had survived a stroke, who had watched his career dissolve, who had spent 4 years wondering if the best of himself was behind him, read a letter that wasn't even addressed to him and decided that it was his problem to solve. Not because he was sure he could win. He didn't know that yet. Because he looked at his neighbor's kitchen table and saw 3 stacks of paper that were designed to overwhelm a 72-year-old woman into giving up. And he recognized what was happening, and he was the person in the room who knew how to stop it. There are people in this world who have been sidelined by illness, by age, by a system that decided they were finished, before they decided that themselves. And sometimes, not always, but sometimes, the very thing that was supposed to write them off is the thing that brings them back to exactly where they were supposed to be. Elwood kept the crystal clock on the kitchen windowsill. He never did throw it away, but I think he understood, after that February, that it was just a clock. The time it kept was not the most important time he'd ever spent.